Everyone, and welcome to this Stowe breakup session on understanding and navigating finances in divorce. My name is Shivi Rajput. I'm a family law solicitor and a partner at Stowe Family Law, and I'm based in our London Victoria office. I deal with a whole breadth of family law issues, but my specialisms really are on high and ultra high net worth divorces, dealing with the finances, as well as pre and post nuptial agreements and complex child arrangements. I'm delighted for this evening to be joined by the wonderful Claire Macklin and Lottie Kent, who I'm going to bring onto the screen shortly and ask them to introduce themselves. But before I do, I just wanted to cover off some housekeeping. So today's session is being recorded and it will be posted to the Stowe's YouTube channel. The recording is also going to be emailed out to everybody who signed up, so thank you very much for doing that. Our panelists will be exploring some of the key FAQs around finances and divorce from different perspectives this evening. We'll be looking at it from the legal perspective, financial and coaching angles. We're not giving advice, but this is some guidance and information that's hopefully helpful to everybody that's joining. And please do feel free to reach out to Claire, Lottie or myself after the session if you require any specific or tailored advice. We are going to have a chat box open for some Q&As that will be open throughout this session. So please do feel free to pop any questions in the chat box. We'll keep an eye on it and answer those at the end of the session. Just as a reminder, the chat box is a safe space, so please do keep anything you post in there friendly. And if you can, try and keep them as short as possible so that we can get through as many questions in the timeframes that we've got. So I'm now going to hand over to my panelists for their introductions. And if I could start with you, please, Lottie.
Of course. So hello, everybody. My name is Lottie Kent. I am an award-winning chartered financial planner and also a resolution accredited divorce specialist. So I'm the director of two companies, True Divorce Consultancy and True Financial Design. So in True Divorce Consultancy, I help people establish exactly what they need from their settlement and model potential settlement scenarios over the top of that need so they can see how whether it fits that need, what the consequences if there are any shortfalls, and how to remove those shortfalls. And then in True Financial Design, we help people structure their settlement once it is received to ensure they're able to live the life they want in the most tax and cost efficient way.
Fantastic. That's great. Thank you very much for joining us, Lottie. And Claire, can I ask you to do the same, please?
Thank you very much. Yes, of course. So and divorce is one of life's most emotionally challenging transitions. So that's what I deal with. My name's Claire Macklin. I'm a specialist divorce coach. I work with individuals to help them navigate separation with clarity and confidence and dignity. So I support clients to manage the emotional impact so that they can stay focused, make informed decisions, and use their professional team more effectively. So I work alongside solicitors and financial planners and advisors to provide a coordinated approach. And I offer everything from one-to-one strategy sessions to intensive wraparound support, to blogs and webinars like this. And I'm also the author of a book, Breakup from Crisis to Confidence, which gives lots of practical tools to help you move forward with purpose.
That's fantastic. Thank you both very much for being with us. I'm sure everybody's going to get a lot out of your respective experiences, so thank you. So without further ado, I'm going to come to our FAQs. So the first question that we have for today is about understanding finances ahead of divorce. And the question is, I am really concerned that I won't be able to manage divorce and post-divorce financially as I have very little in savings and my income is small. Is there any help I can get? How much does divorce actually cost? And will my ex need to pay me any maintenance? Lottie, I'm going to come to you first on this one, please. So from a financial perspective.
Of course. So firstly, all I will say is this is something I hear, one of the most common worries that I do hear. So when someone does have little savings or small income, it's very, very normal to feel very financially vulnerable. And it's also normal not to know where to start. I suppose the good news is you don't need to have a big pot of savings or a background in finances to begin getting clarity. You just need a simple structure to follow. Now, I suppose starting at the beginning, what we really want to make sure you're doing is breaking down everything into 3 clear steps. So the first is understanding your needs. So this is the foundation of every financial decision you will make during divorce. So your needs determine whether maintenance may be appropriate or how much capital you might require and what a sustainable future looks like. So it's about looking at the essentials. What do you need each month to cover your core costs, and what are the child related costs, what your housing needs will be? Do you have any kind of specific health or support needs? And all of this, it needs to be inserted into a schedule of outgoings, which is basically an itemized list of your ongoing expenditure. And what it does is it then provides you with a clear and simple picture of what life is going to cost post-divorce. And it brings some level of order into what kind of initially feels like chaos. The second step, I suppose, is knowing your capacity. So this includes what your current income is and what your future income might look like, especially if you might be considering retraining or returning to work, whether that be part-time or full-time. And I suppose the other part of this is mortgage capacity. So making sure that you're able to either take over the mortgage of your existing home and afford to live in the house that you are in. So I suppose many people assume that they might not be able to borrow anything, and they're surprised when the numbers tell a different story. So one thing I would always say is it's really important just to obtain a mortgage capacity report, because then it will allow you to understand whether you can borrow anything. Because even if you don't necessarily have too much income, it can be, if you are going to end up receiving maintenance, then it can be, you can get a mortgage based on maintenance. And I think most people underestimate how much clarity they gain once they start seeing kind of all of these numbers side by side, and it takes that fear out of everything, and it allows you to start making some informed choices. I suppose the third step is really, really understanding what's available in the joint marital pot. So even if your savings are low, marital assets usually include more than, or often more than, people realise. And that might be equity in the home, it might be pensions, which people often ignore, it might be investments, it might be savings or things held in joint names. Of course, you've got to also remember that it will include debts as well, and that's really important to understand those too. So I think the other things to think about are child benefit or universal credit, because they can also form part of the financial picture. And when you start to see all of it together, you can understand what is possible. I know that Shivi will touch on the actual legal application itself, so I won't cover that here, but I suppose the costs vary from when you're going through financial negotiation. But what I do see time and time again is the earlier someone starts getting financial clarity on what they need and what's in the joint pot and how they can amicably work things out together, if that's possible, it means that generally overall costs tend to be much lower. And I think finally, I just want to bring this back to kind of empowerment. And even if you feel completely unprepared financially, that doesn't mean you cannot create a secure future. Clarity is what changes everything. And it's really once you understand your needs, your capacity, the resources in the joint pot, you'll be able to actually see what your financial life after divorce could realistically look like. And you don't have to have all those answers initially. You just need a starting point, and then you will be able to kind of gain that financial clarity moving forwards.
Fantastic, Lottie. Thank you so much. That's really, really helpful. From a legal perspective, how much a divorce and your associated finances are going to cost will very much depend on the complexity of the asset and really how easy it is to negotiate with the other person. But there are a number of ways that you can manage costs, and there are a number of ways that you can afford them. So you can do things such as attending mediation and trying to get a mediator to assist you to come up with a sensible financial settlement that works for both of you, and then getting a solicitor to draw that up into the necessary paperwork, with the necessary paperwork to make it all legal. Here at Stowe, we do always try and settle our cases, if at all possible, outside of court. It's often much easier for everybody involved, and it's usually much cheaper. But whether or not you're going down the court route or you're doing it through any forms of non-court dispute resolution, there are several ways that you can fund your proceedings. One of the options that I wanted to touch upon today is that it is potentially possible for you to apply for a legal services payment order. What that does is, if you are somebody who just doesn't have the income available to be able to fund their legal fees, and your spouse is somebody that has a lot of money, the court can allow you to make an application for that person to pay some of your legal fees, so to enable you to get legal advice. The purpose of it is to ensure that there is parity of arms between the two of you, so that not one person feels at a disadvantage because they don't have the funds to secure legal advice. They're quite technical applications. You have to jump a number of hurdles. So you have to show, firstly, that there is no other way of you obtaining funds to meet your legal fees, so that you've been turned down for commercial loans, that you're not able to put this on a credit card, you're not able to borrow from family and friends. Secondly, you have to show that the other person can afford to do so, and that obviously you would be disadvantaged if they were able to secure legal advice and you weren't. But in those circumstances where if there is a real power imbalance between you financially, there are options available and you can make those applications to the court. There are several ways that you can fund your legal fees. So if that is something that you are concerned about, please do feel free to get in touch with the team at Stowe. We can talk you through lots of different options. And Claire, just before I come to you, I just wanted to answer the question about interim maintenance. So Lottie touched very much on this in her response when she was saying that it's really important to get a schedule of your needs drawn up. If once you've done that, you're again in a position where there is a shortfall between what you have coming in and what you need to make ends meet and to clear off all your outgoings, and there's a surplus with your ex, then you can apply for interim maintenance. We would again try and agree the amount outside of court if at all possible, and we would try and agree an amount that met your most pressing needs, so that money comes in for you immediately whilst we are dealing with the longer term financial settlement. But again, if that can't be dealt with outside of court, you can make an application for interim maintenance. So there's lots of legal avenues that you can pursue if that is something that you require help on. And Claire, I just want to come to you now from a coaching perspective, just for your take on this particular question.
Thank you. Yeah, so I mean, the first thing I would say is that I see this a lot in my practice too. Kind of fear around the finances is a huge thing for lots and lots of people going through divorce, because it's a bit like a train crash. Your train is going along the tracks quite nicely, and then everything gets thrown into the air, and everything feels like it's falling off the rails, and you can really easily get stuck in fight, flight, freeze, anxiety response to the situation, and that sometimes means that you become paralyzed. Sometimes the discomfort of staying where you are and not facing those fears seems an easier route than actually facing those fears head on. So I always say to my clients, it's really important to get the clarity that Lottie was talking about around the numbers. Even if the numbers come out with a result that you didn't want to see, or there's a gap, at least you know about it. And knowing about it is actually better than wondering whether there is a gap or not having that clarity. So first of all, get the advice that you need. I would always say to get clarity around the numbers. As humans, we like certainty, even if that certainty is not the answer we want to hear. I would also say choose a really good support network, have the right people beside you, whether that's your lawyer, your financial advisor, your coach, your friends as well. Be careful who you listen to. It can be very tempting to listen to lots of horror stories that perhaps your friends have been through horrific divorces, or perhaps some people that have been through horrible experiences. Be really careful who you listen to, and take advice from professionals around you about your situation, because your situation is very different to anybody else's. And lastly, what I think I'd say is this can be really overwhelming. So employ some strategies to help yourself find calm, whatever is happening, calm in the middle of the storm. So first of all, chunk everything down, take each day in small manageable steps, take each task in small manageable steps and focus on the bits that you can control. And learn some calming, grounding techniques. Learn how to box breathe, for example. So breathing is you breathe in for 4, and then you hold for 4, and you breathe out for 4, and hold for 4, and you repeat that. And what I find is that it helps to calm your nervous system, it slows your heart rate, it helps you bring your logical brain back on side so that you can start thinking again. And I think it's really important to practice that before you get to the point of really needing it. So I like to tell my clients, practice doing this every time you boil the kettle, box breathe for the whole time it takes to boil the kettle. And then when you need it, it's like a habit and a reflex. And the other thing I'd say, because we're talking here about somebody who perhaps is really worried about the finances and there isn't an awful lot in the pot, there are lots of free or low cost resources available, as well as paying for one-to-one support from myself, for example. There are lots of webinars like this online. There are lots of podcasts you can listen to. You can invest in various books. You can watch things on TikTok and Instagram. So follow some really good people. If you follow all of us, we will also have links to other people that you can perhaps follow too. So yeah, that's my take on this one.
Fantastic. Thank you so much, Claire. That's some really good tips there, and I will definitely be trying the box breathing. Right, so we're going to come to our second FAQ, and this one is around the family home. So the question is, our home is owned in both our names, and we've lived in it for nearly 20 years. Our children are in secondary school. I really want to stay in the home. It's my main priority to keep the children in a familiar environment. If I want to stay in the home with the children, how can I do this? And can my ex stop me? Claire, I'm going to come to you first for your take on this one, please.
Thank you. So, I mean, I totally understand this feeling. This is one of the most common and most emotionally charged questions that comes up. Because your home represents more than just bricks and mortar. It holds memories, it's stability, perhaps it's the only thing that isn't changing right now. But what I do often see is people choosing to fight to stay in the family home at any cost. And sometimes that cost can be their long-term financial security. And I know Lottie will talk about this in much more depth. But there can be real risks in giving up, for example, a share of a pension in order to stay in a house that perhaps you can't afford to stay in the long run. And I'm not ashamed to admit that I think I did this I've been divorced twice, and I think I did this myself in my first divorce. And so actually what happened was within a couple of years, I realised I needed to move because I couldn't actually afford to keep paying the mortgage and to keep paying all the bills. So my role with my clients is to explore all of this. We look at what are your feelings, we acknowledge them, we explore them. What does your home mean to you emotionally? What does it represent to you? And what would it mean perhaps to think about maybe letting it go? What part of you is holding on to that? And what is it afraid of? And what could you do to soothe that fear? And lots of my clients have already been through so much. So I like to encourage them to use what I call their wow brain and look at what they've already overcome. Look what else they've done that scared them when they first thought about it. And how did they do that? And what resources could they use that they've learnt there to overcome perhaps this? So yeah, really, we're looking at the emotional landscape, and I try and help my clients look at both the emotions and bring in the practical facts so that they can make a really informed, conscious decision about what to do.
Thanks, Claire. And I think that's absolutely hit the nail on the head with that. These types of orders where you are staying in the property while the children remain in a minority are called mesher orders. And typically what happens is that one party, usually the person that the children spend most of their time with, remains in the house until a trigger point. And those trigger points are very commonly when the children reach the age of 16 or when they reach the age of 18 if they finish in full-time secondary education, at which point the sale of the house then goes on the market and is sold and the proceeds are divided between the two. Whether or not that's appropriate very much depends on the individual facts of the case. And just exactly as Claire has said, you have to bear in mind so many different factors. Can you afford to remain there? Are you going to be able to service the mortgage? Will you be able to afford to pay the bills? And what about the other person? Will they be able to rehouse themselves if they are being kept out of their share of the family home for a certain period of time? It's very often believed amongst clients that it would cause less upheaval for the children if they remain in the family home. But some people also argue that that's simply just delaying the inevitable. And as Claire touched upon, and as Lottie's going to explain with other things, if you are foregoing a share of a pension or anything else in order to remain living in the family home, that can have real consequences down the line. So there's lots to think about with that question. Lottie, I want to come to you now from a financial point of view, and would love to hear your thoughts on this.
Of course, and just as you have both said, this is a situation that I also see so often, and especially where children are perhaps in secondary school, the family home feels like one of the only stable things in the middle of a huge amount of change. And it's understandable you want to stay in the family home, but I suppose the key question from a financial perspective is not just whether you want to stay, but whether it's sustainable, not only now, but also in the long term too. So what I want to do now is just break this down into a few kind of key areas if this was kind of your situation. So I suppose the first is affordability. So always starting to understand what's the real cost of staying in the home and what would it be like on your single income. And I don't just mean the mortgage payments, but looking at the really big picture. So the utilities, the council tax, the maintenance, the repairs, the insurance, the general running costs. And especially kind of larger homes, those ones that have been comfortable on two incomes, can feel very, very different financially when the responsibility sits with just one person. So it's a realistic view of the monthly outgoings at first. But then it's looking at, and we've already touched on this, whether it's at mortgage capacity. Many people assume they won't be able to borrow and take on the mortgage, but until you run the numbers or get a mortgage capacity report, you simply don't know. So it's really important to understand whether you would actually be able to afford to take on a mortgage if there is a mortgage there. And I think the other final point is looking at the bigger picture of long-term financial security. So even if staying in the family home is emotionally important, you need to make sure that the overall settlement supports your future needs as well, not just the next few years. Now, this is where pensions and long-term capital planning become absolutely crucial. And if all of the equity is tied up in the property and there is very little left for retirement, it can create a serious financial shortfall later on. As I often say to clients, you can't knock off the chimney and release £50,000 into your bank account. It doesn't work like that. And you see often people so desperate to stay in the family home without realizing how much they're giving up from a pension perspective, and which is then leaving them very financially insecure in the future. So it's really, really important to have a strong foundation of what's not only affordable now, but also in the future. And I suppose the final piece is looking at it and seeing whether there is an alternative that meets your ultimate goal. For example, a slightly smaller home now, but still a familiar, home in the same school catchment area, and or a home that requires less financial pressure, and releases some security, some financial security, is super helpful. So just on that point, what you don't want to do is say, yeah, I want to stay in the family home, and everything you possibly have is within the family home, and then the boiler goes and you've got no liquid cash to fix the boiler. And it's little things like that. It's making sure you also have an emergency fund that you're able to tap into if you need it. And I think I suppose the main point in here is it's not just a question of can you stay in the family home, but what does staying in the family home mean to your long-term financial security? And having that clarity on what that looks like and what that means that you can make confident and informed decisions about what's right for both you and the children in the future.
Fantastic.
I think one thing I'd just to add one more thing, actually, what I see with a lot of my clients, and I've been doing this about 10 years now, is that once the divorce is through, and then it's very difficult to see this at the beginning, but once it's done and it's finished and you've had a bit of time to enjoy the peace that comes after it, lots of my clients then decide off their own bat that they want to move house and they want to have a fresh start and they want to explore living somewhere different, which is quite interesting. So I think that it's worth thinking ahead to, what would future me, where does future me want to be? How does future me want to live? And what does my future life ideally look like? And what's really important to me within my home and within the environment that I live?
Fantastic. Thank you both so much. I'm going to move on to the next question that we have, which is about financial negotiations. And the question is, how do you negotiate a financial settlement in divorce? So from a legal perspective, we need to know what's in the marital pot for division. We need to know what the assets are, we need to know what the liabilities are before we can properly advise what might be a fair and reasonable settlement in your particular case. Family law, we always say, is an art rather than a science. It is very fact specific. And so we need to know what is happening in your case, and we need to know how each of those different assets apply, whether there's tax considerations we need to look into, whether there's liquidity issues. It's all very fact specific. The way that we try and gather as much of this information from the outset as possible is that we ask our clients to complete what's called a Form E. Now, the Form E is the form that you would have to complete if you were in court proceedings. But as I said earlier, we do try and always settle if possible without going to court, but we use the same forms that we need to as if we were in court. The Form E is a really comprehensive financial statement. You can find a copy of it online through the HMCTS website, and you can see what it entails. It's about 30 pages, and it's a one-size-catch-all, one-size-fits-all type of form, designed with space for you to fill in details about any bank accounts that you own here or in any other country abroad, details of your investments, details of any properties that you have, details about business interests that you might have, any employment income that you receive, income from dividends, rental income. And then there's sections in the Form E where you set out what your financial needs are. So the things that we were talking about earlier, your budget, to say this is how much I would require on a monthly basis. And there are sections for you to be able to explain to the court, to the other side, things like what was the standard of living that you enjoyed during the marriage? Were there any particular contributions that one or both of you made to the marriage that you think are important for the court to take into account? Is there any financial misconduct by one party? So, for example, dissipating or getting rid of assets in order to try and frustrate someone's claim, that we say absolutely must be taken into account here. So it's a really comprehensive form that allows you to fill all of that information in. And we usually say to clients, can you fill this in? We'll ask the other side to fill it in as well. And we then hopefully have a very solid picture of what the assets are in the case, the liabilities are, and the potential arguments. We've got something really concrete to work from before we then start looking at what might be a reasonable settlement negotiation and settlement options. Lottie, I'm going to bring you in here about the importance of clients understanding their own financial landscapes and what their goals are before we start the negotiation process.
Course, and I think, when many people think about negotiating a financial settlement, they often imagine kind of sitting at a table debating numbers. But I suppose good negotiation, as Shivi's also touched on already, actually starts long before that. It really starts with understanding your own financial landscape clearly, so knowing exactly what you need both now and in the long term. And by having that clarity, it's so much easier to not be swayed by pressure or emotion or the desire to just get it over with, because you actually know what you need to come out with on the other side. I think so. The first step is understanding numbers, knowing exactly what you need from what your outgoings are. And again, it's coming back to the schedule of outgoings, or what your ongoing costs are, your essential expenditure, your children's costs, what your future housing needs will be, what your life might look like in 10, 20, 30 years time. And then once that is the basis that forms the true basis of a settlement, really. And then once you know your needs clearly, you can negotiate with confidence because you're not guessing. You have a clear anchor which is kind of guiding you. I suppose the second step is understanding the full financial landscape of the marriage. So as Shivi has already touched on, this is the joint assets within the marital pot. So property, pensions, savings, investments, business interests, and any debt. It's when many people are actually surprised about what the full picture looks like when it's laid out in one place. And it often looks very different from a small snapshot that they might have had in their mind. And once you have the full landscape, it becomes much easier to understand what is available to meet not only your, but the other side's future needs as well. So I suppose another key part for negotiating well is understanding what's fair in the context of your finances. Now, fairness isn't always a simple 50-50 split. It's about what each asset means for your long-term security. So, for example, a pension might be just, if not more valuable than equity in a house, but because it's less visible, people often overlook it, or less tangible. So a big part of our role is helping people understand and compare the value of each asset and understand different settlement options and how they will play out over time. And we provide that via cash flow modelling, which provides a visual picture of somebody's finances under each scenario. And I suppose it takes the emotion away from it, because you can actually see a visual picture of what each scenario looks like, and it allows you to make informed choices about your future. I think the only other point I would touch on this is good negotiation is about having the right team around you as well. So you don't need an army of 20 people, but it's having the right people and the right roles in place makes a huge difference. So having a financial expert will help you understand your needs and long-term impact of different settlement scenarios. Of course, the solicitor will help guide you through the legal process, what you're entitled to, make sure everything's structured correctly, both during and after divorce. And of course, an emotional coach helps with your mindset so you can stay calm and grounded and have the ability to communicate clearly. So you're going to be negotiating from a position of strength. And when you have this support team around you, you're not reacting to your former spouse or your ex. You're working with your own plan, and you're being proactive and have the confidence to do so. So I think the key thing is it's not about being persuasive or being a good negotiator. It's just about being prepared, knowing your numbers, both your own numbers, the numbers in the pot, and just knowing what you need in order to achieve that financial security moving forwards.
Wonderful, thank you, Lottie. Claire, can I bring you in?
Of course, yes. So I think that the biggest part that I play here is around supporting my clients to prepare emotionally for those meetings, to prepare emotionally for those, like that exchange of emails and all that kind of thing. One of the biggest things that I find is that often clients come to me and they say, I just wish my ex would hear this or understand this or change this or see my point of view. And one of the fundamental things that I talk about with pretty much all of my clients is understand what you can and can't have power over, and understand what you can and can't control, and control the controllables. So focus on what you can control. It's really easy to lose your way and focus on everything that's outside of your control, especially your ex's behavior, your ex's actions, your ex's words. And you can waste huge amounts of energy trying to control the one thing you can't control, which is somebody else. So when you spend your energy focusing on what they're doing or what they're saying or how you can get them to understand your perspective, you're in what I call, I've got a lovely little diagram for this, which I'm happy to share afterwards, but there's a blue zone in the middle, which is all the things you can control. That's the blue zone of power. So you can control your own thoughts, your own words, your own behavior. And that's the blue zone of power. And then outside, there's this yellow zone of all the things you can't control, other people's words, other people's behavior, other people's choices. And when you step into that zone, I call it the yellow zone of frustration. You are wasting energy on trying to make somebody else different. So I help people to really focus on what it is that they can do. How can they respond rather than react? How can they go into meetings feeling empowered? How can they take back a little bit of control over their everyday lives? How can they deal with the rise of emotion that comes every time an email arrives? So one of the ways in which I do this is talking to people about who do you want to be through this? How do you want to show up? What kind of person do you want to be? And where do you want to get to? How do you want to feel about how you are now in 5 years' time? Because when you hold that vision in the front of your mind, you can start to use it as a kind of compass. So before you speak or say or respond to anything, you can ask yourself, will this move me closer to or further from the kind of future that I want to create and the kind of person that I want to be through this? Because you might not feel that you're in control of very much, but what you can do is steer your own ship. You can steer your own course in terms of your own behaviour. So that's the first thing. And then secondly, strategies around staying calm again. So stop, breathe, think before you respond. And I will say to my clients, you have choice about how you respond, whether you respond, and when you respond. So take your time. Take your time to make decisions, sleep on things, take a pause, take advice, don't panic. This is a marathon, not a sprint. So take advice when you need it. Don't be rushed into signing things or giving answers if you don't feel ready to do that. So yeah, I work with clients around all of those things, and obviously it's very case specific. So it's quite tricky to give advice that will work for everybody. But stop, breathe, think, respond, and make sure that you understand that you are in control of yourself, but you can't control the other person. Think of the big two things.
Oh, that's really helpful. Thank you so much, Claire. Just in terms of negotiation, I just wanted to quickly touch on that. There's several ways that you can negotiate. So you can, again, do that through in mediation with a mediator who's there, an independent, impartial person whose job is to try and facilitate discussions and negotiations between the two of you. You can have lawyer-led negotiations. Now that can involve us all sitting around a table and trying to have trying to thrash it out. More commonly, I would say, it involves correspondence being drafted back and forth, and that correspondence kind of leads into what Claire was saying with it gives you the time to really think about it, to digest what they have said without feeling as though you're sitting across the table from them and you have to respond immediately. It gives you the time to sleep on it, to get some advice, to get some coaching on it from a different perspective, to get some financial advice, to make sure that it would all actually work for you. It's trying to look at everything in a holistic way and not get caught up with the immediate stresses of everything, and for that to feel very overwhelming. So solicitor negotiations through correspondence can provide that natural delay to allow all of those other things to happen. Now, I want to turn to our final FAQs before we open the floor to you with your questions. And this one is about pre-marital assets. So the question is, what happens to assets such as, for example, second or third homes that are only owned in one party's name, or wealth built up from before the marriage? So from a legal point of view, the court in financial remedies proceedings distinguishes between two types of assets, those that are matrimonial, i.e. anything that's been built up during the marriage, and that includes things such as savings, any art collections that you've generated together, wine collections, whether you have invested in shares jointly or whether you have invested in second or third or holiday homes. Matrimonial assets are typically shared on divorce. And there's another category of non-matrimonial assets, and that typically includes things that are bought into the marriage, so pre-marital assets, that includes savings, properties, and family wealth that are owned by one party before coming into the marriage, and anything that one party might have accrued post-separation. Those types of assets are usually non-matrimonial, and ordinarily non-matrimonial assets are not shared in the same way that matrimonial assets are. unless they are required to meet the housing or other financial needs of one of the other parties, or if they have become mixed or mingled with any other family homes or family assets. One of the things that we see a lot more commonly now is people saying that they have generated lots of wealth prior to coming into a marriage and they want to do what they can to protect that. And something that we are advising on a lot more at the moment is prenuptial agreements. So prenups in this country are not yet technically legally binding as they are in other states. It's not like America. It isn't, you've signed this and now you will absolutely be held to the terms of this. But ever since a landmark case in 2010, prenups in this country have been given more and more weight, provided that they are executed properly, drafted properly, and that they don't leave one person in a predicament of real need. So if you are in a situation where you are thinking about getting married and you've got a premarital accumulation of wealth that you would like to protect in the event of a divorce, having a prenup can be a very helpful way to showcase what your intention was prior to the marriage. But even if you have a prenuptial agreement, the crucial thing to remember is that needs will trump all. So if the other party's housing or other financial needs cannot be met without dipping into the premarital wealth that you have, the court can and they will invade that premarital wealth to the extent that's necessary to ensure that everybody is housed and that their needs are taken care of. Because that is the primary goal of the court here, is to make sure that everybody's needs, insofar as possible, are met. I'd like to come to you for your take on this from a financial angle, please.
Yeah, of course. And I think it's just a continuation, Shivi, of exactly what you've just said as that latter point. I think it's really making sure, and I feel like I've drilled this home a lot today, that the needs are correct. So your ongoing needs, so your outgoings on a regular basis, but also your capital requirements as well. So some things that people often forget about. So if you need to rehouse, you need to think about stamp duty, of course, potential moving costs. But the other things that people often forget about are cars and replacing the car, retraining costs if you're going back to work. So they're just making sure that your needs are correct both now and in the future is absolutely critical, because if your needs are incorrect, then how is somebody going to say, right, well, this is what you need in order to maintain your standard of living for the rest of your life? I think where a financial expert and a financial planner can also add value is helping you see whether a proposed settlement is going to fit that need or not. If it doesn't fit that need, what are the shortfalls? What are the consequences of those shortfalls? And how do we remove them? And that's all done via cash flow modeling. And it makes it even very complex situations very simple to understand. And what it also does is allow you to base make an informed decision with confidence, because you can actually see what the future looks like.
Fantastic, thank you. And Claire, your thoughts, please.
So I think, I'd like to take this slightly wider, because something that I hear a lot is where one party says things to the other party like, you're not entitled to have any share of this, or I had this from before, or I've built up my pension over and I've paid it all in, and so you are not entitled to any of that. So I think that it's really important to kind of develop a sort of almost like a snow dome protective layer around you, where if your ex is somebody who says things like that to you, and take a really deep breath and say something along the lines of, this is a process and I'm going to take advice on that, and then leave it and go and take that advice. Because I see lots of clients who are in situations where one person almost uses this as a threat to sort of scare the other person into signing things that might not be in their best interests. So I think that's what I wanted to say about this one is, if your ex is saying things to you that sound like threats about whether or not you're entitled to specific assets, whether they're matrimonial, pre-matrimonial, or whatever, get advice on that. rather than believing necessarily what your ex is saying to you.
I completely agree, and I think it comes back to what I was saying about needs trump all with this. So even if it is something that was acquired prior to the marriage, if actually you can't meet your needs without dipping into that as a resource, then the court does have the power to do that. So if somebody is being very bullish and being, you know, sort of digging their heels in and saying, no, this is mine, you're married. So, you know, the law is there, and you've got a lot of protection in this country. So it's about trying to get the right advice from the right people when you're faced with that, and then, you know, moving that forward, because, you know, the law is kind of on your side with that.
Can I just add to that?
Thank you. Please, Lottie. Yes.
Yeah, just very briefly, and I think just to add to that, the cash flow modelling, I suppose, provides that evidence so that you can actually see. You're not just saying, right, well, I need this, and plucking figures out of thin air, but you're actually illustrating it and providing evidence that will be able to support your case to the other side.
Brilliant. Fantastic. So those were our FAQs. We've had lots of questions that are coming in from you guys, so thank you so much. What I'm going to do is I'm going to go through the questions that we had, and I'm going to put them to Lottie and Claire, and I'll chip in where a legal perspective is required. But for the first question that we have is, for victims of abuse being kept in the dark about finance, not having access to financial information, how can they prove the abuse and have the court ask their partner to disclose more than 1 year of statements? That's one part. And then also, does universal credit impact how much the ex-spouse should give in a divorce settlement? Lottie, do you want to touch on that one?
I will leave the first bit to you, and also I'm just repeating the second question.
So it was about universal credit, and does that impact how much an ex-spouse should provide in a divorce settlement?
And again, that's a legal one, I'm sorry.
No, that's absolutely fine. So from a legal point of view, with your Form E, you are, as standard, required to provide 12 months of bank statements to support for every single account that you've got. Where you need to go back further than that, because if you think, the suggestion in this question here, that this person has been calculating, hiding assets in the lead up to this, you can ask the court to disclose more than that. You can go back 1-2 years, to go back 3 years. I've had cases where people have managed to go back 7 or 8 years because we've got concrete evidence that things were happening within that time frame and that the actions were being taken. It's really important that the court manages cases proportionately, and they will always have an eye on what is proportionate. So if you just go in and you say, look, I have a hunch that this is what's happening, but you don't really have anything to base that on, it's just a gut feeling, the court will not necessarily order any more than 12 months worth of bank statements. But if you've got some concrete evidence, so if you've got bank account statements that are being transferred to different accounts that are not being disclosed, and that you can't follow the paper all the way through, you can raise a request for a judge to determine at the first hearing whether or not they think it's proportionate to allow that to come through. In terms of universal credit, your universal credit, if you're going to receive benefit, that amount is your income. So that would form part of what you receive. Oh, my sound is going.
It's better
Sorry.
now, Shivi.
Can you hear me? Any good?
Yes, better.
Hopefully that works.
Yes. Just don't move.
Brilliant. I won't move. Go on. Sorry.
I was just going to add something, because this question is based around sort of domestic abuse, isn't it, as well? And I was going to say, you know, there are specialist support coaches and therapists out there to support people who are going through divorce where where there is abuse within the relationship. I'm sure she won't mind me saying, but somebody like Karen Kipping, who I know does webinars with you as well, is really good at dealing with this kind of stuff. And also there are lots of charities out there. So have a look at your local charities potentially through your council, and also other charitable things like Dash, to see what support you can get on a personal level as well.
Brilliant. Thank you so much. one was a question, but I think it might have ended prematurely. But it says, as I don't have an income, I won't be able to get a mortgage and will have to put all my assets into. I'm not sure that I've got the rest of that question. Into buying a house. Okay. So as I don't have an income, I won't be able to get a mortgage and will have to put all of my assets into buying my house. How do I fund day to day? Lottie, is that something that we could come to you on, please?
Of course, that's a good question. And I think what's really, really important, it comes back to what we were talking about as one of the FAQs. I think, yes, it's what you don't want to do is make sure that all of your eggs or everything is tied, all of your assets and everything is tied up within the house. I appreciate that sometimes it's very, very difficult to keep that little bit back. But you want to make sure that if you can at all, you've got sort of an emergency fund. So we generally say about 3 to 6 months worth of outgoings that you're going to keep in cash and in capital, and try and build that up as quickly as you can if you don't have that initially. And I think the other things to think about are when things are tight like that, are being creative and thinking about ways that you can earn a little bit of money, say around the children. And there are, the world works in a very virtual way now, and there are some very, very creative things that can be done to earn a little bit of money on the side as well, to try and help maintain kind of standard of living as well.
Brilliant, thank you. I'm trying to rattle through as many of these as we can. I've got another one that's come in that says, I've applied for a divorce and the 20-week waiting period started on the 22nd of October. My husband, who's a barrister in civil litigation, is refusing to refused to acknowledge the divorce application and refuses to complete the Form E that my lawyer has sent him. Can we agree a financial settlement without completing the Form E? Claire, can I come to you about that just from a human being point of view, and then I'll answer the legal element of that.
Yes, the refusal to engage part. So I'm going to take it a little bit wider than just this question. And something that has come up in sessions with me before is really thinking about where that refusal to engage is coming from. Because sometimes it's that this person is very difficult, narcissistic. It may be coming from there, but it may also be coming from a place of fear and paralysis. Obviously, we don't know in this particular situation. So it's worth stepping into the shoes of the other person and just thinking, where is this coming from? Is there anything that I can do to perhaps assuage some of the fears that might be underneath, for example? And then, of course, if it is that person is refusing to engage just because they absolutely don't want to acknowledge what's happening, they absolutely don't want to engage in it, they are, almost saying, no, this is not going to happen and I'm not going to let it happen. And then I think it's absolutely time to go and take some legal advice about what you can do to essentially force the other person to the table. So, in my experience, it then starts to involve perhaps making an application to the court to get a timetable in place and so on. And I always say to my clients, don't be afraid of that. It sounds like a really scary thing to do. Sometimes it's absolutely the right thing to do because it will bring in a timetable and it will give you deadlines, and it will mean that there are consequences if the person continues to refuse to engage.
Absolutely. And I think from the information we've got in this one, so a barrister in civil litigation, but is refusing to engage with all aspects of this. So hasn't acknowledged the divorce, isn't going to engage a lawyer, isn't doing the Form E. For me, as a lawyer, that rings a lot of alarm bells. If somebody doesn't want to complete a Form E, and they're not just being, worried about the whole process, it to me screams as though they have things that they're trying to hide and they don't want to do that. So yes, it is possible to agree a financial settlement without engaging with a Form E. You don't have to do that. You can come to an agreement between the two of you, and that can be embodied into a consent order that is then sent to the court for approval. I would say it's dangerous to do that. And whenever we get clients that say this is what's happening, but we don't want to engage in a Form E, we give them very strong advice that without knowing everything that's available there, without seeing, and not just what they're saying is available, but without seeing the bank account statements to back it up, the evidence of the investments, etc., we can't tell you whether what is being proposed or what you are proposing is fair or reasonable. So it's really risky to do that. Touching on again what Claire said, don't be afraid to issue court proceedings if you need to. It will create consequences if he refuses to engage. So now, when you have a family law court order, a penal notice is automatically attached. And what that means is that if a person breaches the order, so if they within the court timetable, they will have to fill in a Form E by X date. If they don't do that and you write to them and they are just not engaging, then you've got a penal notice already exhibited to that order, which means that they can be held in contempt of court if they refuse to engage. And the ultimate punishment for contempt of court is imprisonment. But you can also have a fine imposed upon you. You can have your assets seized. You can have costs orders made against you. So it gives you a bite, something to bite, that's something there that you can actually fall back on if this person is just refusing to engage. You can also ask the court to draw inferences. So there are circumstances where we've done all the digging that we can do and we're just never really going to get to the bottom of it because perhaps they have been very clever, but we can't get to the bottom of it. We can ask the court for inference, so we can say, and we can't provide evidence that this has happened, but it's very reasonable to assume that it has, and can you work on the basis that this has, because he's refusing to provide the information that we need for us to be able to look at this in concrete ways. So hopefully that helps. Lots of things that you can do. I am very, very conscious of time. I think we're just going to have to pick one more question, which if I kept the house, I wouldn't be paying more tax in the future, or should I sell it now? But I'm not sure that's something that we should necessarily advise on, but if it's within your
You've gone slightly
remit.
robotic. I'm so sorry. Do you mind just repeating that?
I'm very sorry. Is that better?
Yes, much better.
The question was, if I kept the house, would I end up paying more tax in the future, or should I sell it now? And I was just saying, I'm not sure whether that's something that you could necessarily advise on, but if it's in your remit, then
yeah, it's not. I'm not an accountant, I'm not a tax expert, but I can give some generic kind of input on that. So basically, it depends, first of all, whether it's your main residence or whether it's a second home. And I think it's really important to just find out the facts on that first. But it's also, you raise a very, very good point there on whether on the situation and whether and getting the right information up front. So speaking to a tax expert and fully understanding that. When I always say this to clients, if you're not looking at the net cost, so if you're taking the total cost of a property, say for example it's worth 300,000, and then you're selling it and you've got capital gains tax to pay of say 30, that's very different splitting 270,000 to 300. And it's really making sure that, again, just knowing your figures, knowing your numbers is absolutely critical. So just seek the right advice to get the answers.
Fantastic. I think that's great. We are coming to the end of the session. I know we haven't been able to get through everybody's questions, and I apologise. We are going to send out a follow-up email, and there will be contact details for all of us if anybody wants to get in touch to ask a specific question. But I really hope that has been helpful for you and that we've answered some of the frequently asked questions and some of your tailored questions. I just want to take this opportunity to send a huge thank you to Claire and to Lottie for joining us today. I really hope that everybody has found it as useful as I found it, listening to you from your different perspectives. And thank you all very much for joining and giving up your evening to be here with us. This is our last Breakup Club of the year. There will be a Stowe Talks webinar with a guest presenter, Chloe Odiz. Sorry if I've pronounced the name incorrectly, but she's a divorce coach, and that will be taking place on the 21st of January 2026. And that will be about setting yourself up for success from the start of your divorce. So a really interesting start to 2026, and that will be available to book soon. But thank you again to Lottie and Claire and to everybody that's joined us for today. And we hope to see you again on one of our breakup clubs. Thank you very much.
Thank you.
Thank you.